for the brief bench conference.
Thank you.
We are here today for we are here today for bond violation as well as probable cause conference. As to the bond.
Today's docket looks routine until you catch what's really happening. A bond violation gets handled quietly, a controlled substance count gets dismissed, and the defendant is walking a tight legal line where one mistake can cost him freedom. Then the courtroom shifts again. New cases, new tone, and one request that turns legal procedure into a human test. Stay with it, because the small details here decide everything.
Violation first, Mr. Cummings is going to admit he's going to plead no contest to the bond violation.
So he admits to the violation.
Yes, Judge.
Or at least does not contest the violation. All right. Okay.
And as to the underlying charge, Mr. Cummings would like to avail himself of an offer from the people. In this instance, the people will be dismissing count 1, controlled substance possession, and Mr. Cummings will be pleading guilty to an added count 2 of misdemeanor use with dismissal under 7411 upon completion.
That's the court's understanding of what's here. May I have him sworn?
Raise your right hand. You solemnly swear the testimony you're about to give will be the truth. The whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Daniel Cummings.
Sir, it's this court's understanding you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year, $2,000 fine plus court costs. Do you understand that?
Yes.
Understanding that, you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo or her successor in the 15th District Court. You understand that?
I understand what you're saying. I just don't understand the process, but yes, I understand. I just
don't understand what
She's not going to be, so you're playing, so Judge Simpson is taking your plea, but Judge Valvo will be the one that sentences you because it's a different.
Am I getting sentenced?
Not today, no, but by Judge Valvo.
Sir, you have a right to have
Thank you. I
the
understand.
judge taking your plea to sentence you in this case. I have your form that indicates you waived that right. And I'm just advising you that while I'm taking your plea, I would not be your sentencing judge.
Oh, okay.
If you don't want that to happen, then something
No,
else is
it's
going
what-
to have to happen.
However it works is yes to me.
But you understand that? And you're waiving that, right?
Yes,
Okay.
that's good, right?
Yes.
You understand it?
Yes, I do.
All right, good. So understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Let's decode that offer in plain courtroom terms. The prosecutor is dropping the more serious controlled substance possession count, and the defendant is pleading guilty to a misdemeanor use count. The key phrase is dismissal under 7411 upon completion. That signals a structured outcome. The case can be dismissed if the defendant completes the required conditions, but it's not automatic. Also notice the judge clarifying who sentences. This judge is taking the plea, but the sentencing will happen before a different judge in district court. That's normal in many court systems. One judge handles the plea, another handles sentencing or probation review. And if you're a defendant who doesn't understand the process, this is exactly where confusion can wreck your choices. So, question for viewers. Would you take a deal you don't fully understand just to get out of immediate risk?
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Looking at paragraph 5, you'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, I mean, I wasn't until I came in.
Yes, it's yes. Yes, sir.
Okay. At the time of this offense, were you on probation?
No,
At the time of this offense, were you on parole?
no,
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no, they have not.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you're guilty of this offense?
Yes,
March 5th, 2025, at the location of 1620 East Medical Center Drive, City of Ann Arbor, Washington County, State of Michigan. Did you have heroin in your possession?
yes.
Had you used it?
I did before that day, but not on that day. But yes, I've used it. Used it.
Did you?
That one.
On or about March 5th, 2025, at that location, did you have heroin in your possession?
Yes,
Had you at some point used that heroin?
not that day, but prior.
But around that day.
Yes, right around that day. Okay, I'm sorry.
And
Your Honor.
did you know what you were using was heroin?
Yes,
Sir, I do have to advise you that if I accept your plea, and if between the time of your plea, between the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
yes, I do, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not.
No, Judge.
And have I complied with the court rule?
You have.
People are satisfied, thank you.
Defense is satisfied, Judge.
Court will accept the defendant's guilty plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
January 20th at 9 a.m.
January 20th.
Yes.
January 20th, 2025, 9 a.m. How long has the defendant been in?
I think 24 days?
26.
26 days at this point, Judge.
They should be able to get to him relatively quick because I'm not reducing his bond until such time as they get a chance to see him. I'll hear from you, counsel.
Thank you, Judge.
On the violation, he's been in 26 days. I'm going to sentence him to 36 days. Credit 26 days. As to bond.
Thank you, Judge. So, Mr. Cummings, this is his first time with the criminal justice system. He's 59 years old with no record, no prior convictions. He's done quite a bit to get himself clean. For one, he's been in custody and clean and not using the whole time. He is on the waiting list for Dawn Farm in-jail treatment program. He was previously, before he got arrested, before he became into custody, he was trying to get into a detox program at U of M. He became addicted to opioids as a result of a lot of health problems. He had a prior prescription, but was eventually cut off, leading to his addiction. He is an Air Force veteran. He was honorably discharged in 1988. He's been married for 41 years. His wife is battling the early stages of Alzheimer's. He's got a very supportive family. His 26-year-old son is local. His parents are here in the courtroom as well, and they can help him. Your Honor, and as to getting back to his treatment, he has a number of treatment programs available.
This is where courtroom math and courtroom strategy collide. The judge sentences 36 days on the bond violation, then gives credit for time already served, meaning the defendant doesn't start from zero. That's why the defense keeps highlighting he's been in custody 26 days and is already clean while in jail. But catch the judge's logic. Bond isn't reduced until probation interviews him. That's not punishment for punishment's sake, it's risk management. The court wants a structured release plan, treatment, supervision, and stability before loosening conditions. And the defense's mitigation is strong. 59 years old, no record, veteran, wife with early Alzheimer's, family present, treatment waiting lists. Still, the court is basically saying, I need the system to assess you first. Viewer question? Should courts prioritize immediate release when someone shows rehab intent or insist on official verification first?
To him that he is basically ready to go to. If he was released today, he would be able to go to, he's got a 7 blocks away from his house. He's got a...
I'm not going to have any problem. So he's got to serve at least another 10 days.
Okay.
The purpose behind sentencing to that is so that 15th District Court probation can interview him, look at it, and decide on what is the best form of release. If they don't see him in those 10 days, then his bond is going to go back to what it was previously, and he would be released.
Understood.
So
Thank you, Judge.
Is there anything else?
No, Judge, and I appreciate the opportunity to allocute for the record.
There's nothing from the people. Good. Thank you.
Thank you, Your
Thank you,
Honor.
Judge.
Motion for bond reduction denied.
Thank you, Judge.
Court calls the case of the people versus Antonio Boswell.
And good morning, Your Honor. For the record, Terry Johnson, on behalf of Mr. Antonio Boswell, who is approaching and stands to my right. State your name for the record, sir.
Antonio Boswell.
Thank you. All right, what are we doing?
Your Honor, I've had an opportunity to speak to my client. We're going to request our exam in this matter.
12 days out is one. The 13th, right?
13th.
Discovery is complete, correct?
I've received what they've given me, Your Honor.
Okay. That's good. And would the people have their witnesses available January 13th? Preliminary examination in person, January 13th, 2026, 9 a.m. Hold for one moment. Do we know? It'd be before 15th District Court Judge. I don't have a name.
Do I get to pick? I'm just asking.
Sure. So I can tell the others that you didn't pick them. So go ahead.
Judge Judy, Your Honor.
Nice. All right. So that's all that we have right now. And I don't know if it's appointed soon, whether they're going to be ready to go on the 13th. I have no idea.
Understand. Thank you, Your Honor.
We'll figure it out. All right, bond will continue. Thank you, sir.
Your staff have a good day and great new year, Your Honor. Good to
do the
see you.
same, sir. Court does call the case, people versus de jure, Bond Sanders.
And then on behalf of the people,
Oh, I was gonna call.
Stephanie Cannon on behalf of Mr. Bond Sanders. Mr. Bond Sanders, you are present. Please state your name for the record.
Bond Sanders.
And Your Honor, we are asking for a brief adjournment of this matter.
Is this the only thing holding him?
he has a hold out of your report from his violation of probation.
So, no, Your Honor.
Good, Ken.
Your Honor, when appropriate, I'd like to address bond.
Probable cause conference will be adjourned January 8th, 2026, 9 a.m. Bond can, yes, as the bond.
Your Honor, currently my client has no phone privileges. He understands the reasons and the whys for that. He's exceptionally apologetic. He wants to know if he can just have one phone number that he can speak with. His daughter has medical needs. She has multiple seizures. And he wants to just be able to talk to her. And if that's the only phone number the court is allowing, that's what he's asking for, to speak to his child. How old is she?
She's 2.
And Your Honor, I'm not sure they're revoked on these cases. This is his first PCC for these cases, so I'm not sure which case it's revoked on.
I would imagine it's the other case.
Thank you, Your Honor. I will try to get a request in on the other.
Stepping back professionally, this hearing is a snapshot of how courts balance procedure, public safety, and human reality. We saw a negotiated plea where a more serious count was dismissed, a misdemeanor plea was entered, and sentencing was set for a later date. We also saw bond handled as a tool, not a reward, kept firm until probation can evaluate the defendant and recommend the safest release structure. Then, in later matters, the tone shifts into courtroom culture, respect, limits, and authority, because courtroom outcomes aren't driven by emotion, they're driven by rules, timing, and credibility. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.